Yes.
And to make a mention, Your Lordship.
Recirculation.
Your Lordship, on behalf of Mr. Ponda, Your Lordship, item 6 and 40, Your Lordship. It may be
Yes.
taken up some other day next week, Your Lordship.
No, I'll not adjourn. 6 means this is
Someone passed away, Your Lordship, from Mr.
no,
Ponda's
95.
family.
Let it be there. We'll see. Huh? Let it be there. We'll see. Yes. Yes.
Report. Item 1.
Item 1 report residing at their village,
Alive, huh?
alive.
Yes. 2.
Item 2.
Item 2, the only appellant is died on 5/5/2018.
Only available? Okay.
Died on 5/5/2018.
5 220. Permitted in the absence of an application. So permitted.
Item 3.
Item 3, there are 15 appellants, and out of whom
We'll see who has died and
Times died.
permitted. The
Appellant number 13. And others.
rest are there. Yes.
Item 4.
Item 4, may I please, Your Lordship, my lord?
Yes.
Here, my lord, considering my long incarnation, my lord granted me interim bail for a period of 3 months. And already, my lord, it's a part-hard matter. I am praying, my lord, 1 month extension. And my lord, fix the date of hearing. Thereafter, I will surrender, my lord. Out of 10 years imprisonment, I am custody more than 5 years.
No, you have moved an application for extension.
Extension, my lord.
Where is that application?
That is, my lord,
IN
item number 567.
When is this interim bail? Expiry?
4 तारीख ଆଉ ଗୋଟେ ମାସ extension ହବ।
Will extend one.
During that period, will not involve me.
See, same condition. For the appellant was admitted to interim bail for 3 months, huh?
Yes.
3 months. 3 months by the order dated 18/9/2025.
Yes.
2025, right? 9. Sorry to when you were released.
ଆରଟା ମୁଁ 31/11 ବାହାରିଲି। 2 connected appeal ଗୋଟେ ୱେଟ୍ କଲା 2 ଜଣ ଏକା ସାଙ୍ଗରେ ବାହାରିଛନ୍ତି। ସେ 11/2025 ପରେ
When you got released?
ମିଲର ମୁଁ got release ମିଲର 31/11/2025।
Okay. Pursuant to the said order, the appellant was released from custody on 30/11/2025. Therefore, the 3 months 3 months interim bail period is expiring on
4/3/2026.
4/3/2026. Prior to the expiry of the 3 months interim bail period, the present application has been moved. For the reasons stated in the application, the same is allowed, and the interim bail period of 3 months is extended to further 1 month. Further 1 month, and the condition is imposed by the trial court or this court.
Trial court.
Condition imposed while enlarging on interim bail shall remain same. Remain same.
Connected ମିଲର ସେଟାରେ 27/11 ହେଇଥିଲା ଇଣ୍ଟରଭ୍ୟୁ।
Where is that? Another matter.
Another sub item.
That's sufficient of 1 month. What give the dates when
same date ମୁଁ ଏକା ସାଙ୍ଗରେ ଦେଲି।
release on the same day, but the bail order was
27/11/2025।
27/11.
4/3 ହବ।
Bail order and release on 17, expiring on 17.
One more prayer, my lord. Since it's a part-hard matter, sorry, case, did note this. Aro saptaku rogu, my lord.
No, but it is, I don't know. I gave the bail, I am extending, but it is to 2024 appeal. It has to be heard by someone else.
No, my lord. It's a special assignment, my lord.
Then we will hear it.
Aro saptaku rogu jama hearing conclude surrender kale, my lord, judgment saja confirm.
But you show your bona fide.
Sorry,
once you are convicted, suppose I will appeal the conviction, then you will escape.
No,
Because you are in interim bail. That is your idea. I'll hear it, but unless you surrender, I will not.
Yes, that.
Okay.
Next week, hearing.
Include kar deta.
Hearing.
Yes.
Unless surrender, the matter for
Yes. Okay, then.
Okay.
Yes, madam.
I beg pardon, Your Lordship. Your Lordship, item number 3, on behalf of Mr. Mishra, I am praying for an adjournment.
Report by.
Report has come, don't worry, huh? Report has come, it will remain in the list, get ready. Yes. Yes, sir. Dago, bolo.
Item 5.
Item 5, file was not with me, file Deinahati, the liability dash Gurwar.
6. These are 95 meter, right? Not urgent. We'll proceed. Huh?
Item 6. Yeah.
Hmm?
Online BC there.
That's a 6 months. 7.
Item 7.
7. What is there? So let us start. Who, you are there in 7? Who is there?
In 6, Your Lordship, I was there.
Seven. Who is there? You are not there. Mr. Panigri, you are there. Huh? 21. Who is there? Huh? That's the whole difficulty. Mr. Panda, you item 7, just check it up. We'll proceed. Otherwise, there is no end to it, you know. We can't wait for the people like this. We'll read together. All of us will read together. I also am not ready. Nobody has read it. Let us read it together and finish it up. 95 matters. How much one can wait? Mr. Bose, you are in any matter?
Yes,
13. 1 3.
30.
30. 1 minute. 30. Give it to Mr. Panda, item 7. Huh? He will read by that time. 30. Huh?
Yes.
Oh, if you are ready, then 30. You start. Mr. Panda, you read it. 5, 7. 7, Mr. Panigre, you just see 7. Huh? I will, meanwhile, I'll hear Mr. Bose, item 30, a small matter maybe. By the time 7 will be ready.
My matter.
Okay. What is this matter? 30. Right? 30 करो भैया करो दिखा Thirty. Evidence for evidence. Print Arjuna Chand. Print for. The CPW2 is the injured. Read it.
Informant PW1 is my nephew. I know the accused standing in the dock. The occurrence took place on 26/7/2002, at about 8 p.m. The alleged occurrence took place in front of veranda house of Hrusikesh Samantrai.
Yes.
I was not present in the house. I had been to our agriculture field. When I returned to my house, I heard from my wife that daughter of Prasanna Bariyar Singh, the niece of accused, has been to pass bowel and my son passed on that way. So the parents of the daughter suspected my son to have told something and they came and forcibly took away my son from our house. Then I had been to outside, and when I returned, Dukhi Sam inquired from me as to what happened. I narrated the story that I told what I told earlier above. In the meantime, accused Pankaj came and assaulted me by means of farsa on my left elbow and two legs, causing profuse farsa blow. uh, and legs causing profuse bleeding. My wearing apparel were attended with blood. Then my nephew, my wife, and others gathered and took me to PS. From there, I was taken to Khurda Hospital. From Khurda Hospital to Capital Hospital.
Also, car witness.
It PW2.
Injured.
My nephew PW1 lodged a report as he learned the alleged fact from me. Cross-examination.
Informant.
There is one
PW1 is the informant,
PW1.
isn't it?
Yes.
Yes. PW1 is the informant, and he has not seen it.
No.
He has not seen it. He
Prepare the convenience note if you're not
Huh.
sure.
Yes.
But here the brief facts of the case is like this.
Hmm.
One Ashok Kumar Pradhan lodged a report before the voice judge stating that on 26/7/2002 at 8:30 p.m. when he returned to his house from Bazar, he found one Jaykrishna Pradhan, his elder father, has been assaulted by Pankaj Bariyar Singh. But he had not seen the witness.
Yes.
There were two witnesses who have seen it, and both of them turned hostile.
So who are the
Yes,
witnesses?
those are my lord PW. My lord,
Accused person, the appellant by means of farsa.
PW8, he
PW
has turned hostile.
and PW2,
8.
PW8 and
PW8 turned hostile.
Hmm.
PW5 and 4 are the eyewitness, but subsequently they denied to have seen the
Seen it.
appearance.
PW
PW4 and PW4 and PW5
5. Not supported fully.
not supported the prosecution. PW1 was just a hearsay witness.
Who is the informant of?
Yes.
Let us close. He further got.
Learned trial court.
Now you are reading this. Let us go through.
But the background is the nephew who has lost the affair was involved in a 376 case where the accused daughter was subjected to rape. But I want to draw a conclusion before your lordship, subject to what your lordship, that there was a case before launching of this affair, and he was involved in molestation of the daughter of the
Accused.
So there
This
was
informant. This informant.
this informant. So there was a idea to somehow nail this accused person. Now question is, the learned trial court in the judgment, I'll place that portion, found that there was discrepancy in the timing, but said that nobody on earth, nobody will watch the time when the assault was there. But here I would like to beg to differ from the learned trial court on two aspects. First is, when you allege assault, you should be specific at what time the assault was done. Just a wayward statement that I had heard that he had assaulted. The persons who were seen.
But how will you get over the injured witness?
injured witness, my lord, he could not say the timing. The court below accepted that statement, saying that it is not mandatory the timing has to be there.
Yes.
Because he was injured. So injury means result that there was an attack.
Yes.
But a suggestion was given to all the witnesses that he was working at that time in the field and he might have slipped in the mud and the injury might have caused due to that.
Acha.
The IO was never brought to the dock. The doctor was never examined.
IO doctor not examined.
No.
IO
And doctor was never examined.
not examined.
IO, the learned trial court says, because the IO, even if the IO is not examined, it will not materially affect the prosecution.
Because it has not prejudiced you.
Yes.
You not that's
This matter, the person who has investigated the crime, he is a material witness for the prosecution.
no. For the peculiar facts of this case, he may be material witness because the informant is involved in one of the
Yes.
case where the daughter of the accused is involved.
Yeah.
So therefore, how the information has come and what triggered.
What
Therefore, the IO may be a material witness.
material.
Therefore, you can say that you are being prejudiced, but not bringing IO witness.
This
Correct.
is some
Facts of this case.
this is some substance of
And let us see the injury report is exhibited or not.
yes. But then let us
Exhibit.
corrected asking that injury report.
Let us see the injury report.
The injury report exhibit 3.
Yes. Bleeding injury on his head, kya hai? Left side head.
Yes.
Who is given?
The doctor. But if the doctor would have come, I could have
No. Where is the signature? Nothing. It's a plain paper.
plain paper.
What is written there? Just see. It is two. Take it out from there. Exhibit 3. Come to exhibit 3. 2 the MO DHH flow. Who is given to whom?
This is 2 MODHS.
No. Just see signature. Yours faithfully.
Yes.
SIA police. SIA police will give the injury report.
No.
Then
That should not be.
SIA police has written it.
Yes.
He found these two injury. That he is not examined. What is this kind of? The injury is not proved at all. Then.
My lord, if the doctor would have also come, I could have asked him a question.
Who is the doctor?
Nobody. My lord, even let us go to the extent of saying the doctor would have come.
Doctor name is not there. Nothing is there. Who is the doctor? You see what is written there in the here. Jaya Krishna Pradhan son of so and so.
Who MODHS
Come for
Khordha.
Doctor.
Jatni PS.
What has he written?
I
There
beg
was-
to report that the above noted injured received
those
filing
two-
as he was assaulted by Pankaj Balia Singh on 26/7/2002 at 8:30 p.m. by means of farsa.
No, this is written by the IO.
IO.
You just forget.
Yes.
In the down it is there. See, there it is written. You are faithfully SI of police.
Jatni PS.
Jotni PS. That part is police. Police can't give.
Yes.
And thereafter it is written. Just see. It is written Jaya Krishna Pradhan,
Son of
so
Gokul Pradhan.
patient
Hmm.
came for
Opinion.
operation
Operation after
after
from-
returning from hospital.
hospital.
Hospital. There was an
Campus.
old stitch,
Stitch.
wound,
Stitch wound on the post part of the
post part of the
First, left arm with
opinion. It was from that. What is this? When he is gone, there was a stitch. There is nothing. What kind of injury he has received? IO says 2 injury, and doctor doesn't say anything. Right of the medical doctor's handwriting reading is very difficult.
That's why one report one.
See, operation on 2/9/2002.
There was an operation.
2/9/2002.
Yes.
No, that is this is happened on 26/7/2002 incident. The operation takes place. The doctor says operation on 2/9/2002. Operation after so many months, 2 months, about 2 months. On operation, it was found that there was
overrating is date.
old. There was
Injury report.
nature is grievous. Sharp
Sharp
cutting
cutting
weapon.
weapon.
ये क्या है? What kind of evidence? How will you justify this? Exhibit 3 निकाल दो, print out निकाल दो.
I was arguing a case before Dr. Justice Panikri. His handwriting came. He said, from today onwards, if they don't write proper handwriting, I'll discard those reports.
It's very difficult to read.
difficult to read.
My lord, we are unable to read how your lordship will read.
Very difficult. And now digitalized, so therefore you can expand it.
Yes.
Bit. But
My lord, this is the
There was an
positiveness of
old-
this digitalization.
it is written there was an old stitch wound on the post part of LY third L3 of the left arm with
My lord, your lordship will see there are 2 dates. One is 26/7. One other is-
26/7 is the incident.
Yes.
And
And it is
operation took place in 2/9/2002.
7/10/2002, he gives a report.
And he gives 7/10/2002.
That was the final opinion by the orthopedic surgeon who conducted surgery.
Nobody's, we don't know whether orthopedics, who is he.
In the initial, that is not there, but in the initial
There-
report,
None of the doctor is examined.
yes.
How will you, how have you proved the injury
that
to
is
bring
very much.
324? And eyewitnesses? You see eyewitness, who
Yes.
are the eyewitness according to you?
My lord, will kindly see
Hmm.
eyewitnesses number. My lord, 4 is Panchanan Jena.
He didn't support.
No.
And
Where I
5,
place it, man. I know accused Pankaj Baliwar Singh. I also know injured George Krishna Pradhan. The occurrence took place 2 years back. It took place in our Sahi. By hearing sound, I went to the place and incident and heard George Krishna Pradhan was assaulted by the accused, causing bleeding injury. Defense. I was not examined by police. I cannot name the person. from whom I learned the facts of the occurrence. Then EW5, your lordship will see.
I came out from the house and saw that Jaykrishna Pradhan was lying, being injured,
Yes.
and hand was cut. From the injured, I learned that the assault by means of Farsa. He has not seen it.
No.
Then the injured was shifted to.
My wife, nephew, and some others accused is a habitual offender, and there were cases against him. The witness is declared hostile. It a prosecution order. It's not a fact that I was examined by the police, and it is not a fact injured sustained injury by fall again, sharp and rough metal, and due to the previous grudge on accused, he has foisted a false case against him. It is not a fact that I have neither seen the occurrence nor heard about the occurrence from the injured, and now I'm deposing false.
And how exhibit 3 through whom it was through whom? Huh? Through whom it was brought on the court?
The judgment is also silent on that aspect. Your lordship will see the judgment.
Who is PW3?
EW3 is my lord.
Injured is my husband.
Yes.
Informant is my nephew. The occurrence took place about rainy season. Of course, his wife came to our house.
My lord will see the defense. There is a case against my son concerning affairs of daughter of Badia Singh. The said affair took place in the evening of the occurrence day. It is not a fact that my son was taken away from the spot where daughter of Badia Singh went for latrine. It is not a fact that my son was not taken from our house. Our house situates intervening by 7 to 8 houses from the house of Husike Samudra. There are houses near the house of Husike Samudra. I have seen Pankaj when he went armed with Farsa. I did not call others by shouting when I saw Pankaj was proceeding armed with Farsa. The wooden portion of Farsa would be about 1.5 cubit length, and the iron portion of the Farsa would be about 0.5 cubit length. He assaulted my husband from a very close distance. I followed the accused at a distance and did not try to hold to him prior to his assault on my husband. Our house and house of Pankaj adjoined to each other. The height of the veranda of the house of the Husikes would be about 2 cubic height. The injury near elbow almost covered the entire arm, and the hand was hanging. But if this was there,
She is an eyewitness then.
yes,
Yes, ma'am.
yes.
She is an eyewitness.
My husband was on the veranda and accused assaulted him standing on the floor below the veranda. After my husband fell down, he was assaulted on his legs. I cannot say, I guess that what would be the time when I reached PS. The alleged assault took place at 8 to 8:30 p.m. It is not a fact that on the day of occurrence, my husband sustained injury by fall, and there was an earlier case in the same evening against my son, and this false case has been busted by subject.
Then for prosecution, then only injured and this witness is there, wife and husband. And the informant is the nephew who was involved with the daughter of the accused. This is the story. And there is no other document. IO is not examined. There is no medical evidence.
Doctor is also not examined.
And 320. How the trial court deals with it?
Yeah. My lord may kindly turn to paragraph 6. He discusses who is hostile and what they have said. I am not facing it. From the discussion of the evidence, of witness, it is seen that the informant PW1 injured PW.
Where are you reading?
Paragraph six,
Paragraph 6 of
running page 5 of the improved judgment.
From the discussion.
From the discussion of evidence of witness, it is seen that the
That the
informant
informant
PW1
PW1
injures PW2, wife of the injured PW3, occurrence witness PW4, the material occurrence witness PW5, who have been named in the FIR, have supported the prosecution case. The evidence of these witnesses have not been assailed by the defense during cross-examination. There are only discrepancies regarding the time of occurrence. The above stated witnesses are not experts or technical persons, but are laymen. It is not concerned person to watch to know the time. So there is no ground to doubt or disbelieve the evidence of the above stated material witness. The evidence of these witnesses is supported by seizure of wearing apparel of the injured by seizure list and evidence of PW6. The alleged assault also gets support from the injury report marked exhibit. But
Injury report, where is the injury report? There is no injury report.
But most probably they may say that 3.
Exhibit 3.
That's not.
There is no discrepancy in the evidence of witness and the injury report regarding place of injury on the injured. The FIR has been proved by the informant. The only drawback in the case is IO has not been examined. It is seen from the record there is no material thing in the cross-examination of witness to be confronted to IO. So, defense is no way prejudiced for non-examination of IO. On the other hand, prosecution has been prejudiced for non-examination of IO, being unable to confront suggestion made to the hostile witnesses PW8 and PW7. On the whole examination, the IO is not fatal to the prosecution case, and in spite of all steps taken by the prosecution before and court, IO has not turned up to adduce evidence. From the entire discussion, the evidence of the record, it is held that the prosecution has been able to prove the case beyond all reasonable doubt against the accused person regarding assault on injured by the accused, but it is seen that there is no iota of evidence or utterance by any witness that the alleged assault was done with an intention to take life of the injured. It is also not established from circumstantial evidence on record. Altogether, report of the doctor is simple in nature. So the ingredients of 307 are not attracted. In the result, accused is found guilty of 324 instead of 307. But as your lordships rightly said, the present fact and scenario of the case, the IO was the most vital witness.
Because of this
This scenario.
particular thing, yes. Yes, but
Injured is PW1 and PW2 is wife. They are just supporting.
PW2 is injured, PW3 is the wife of the injured. Yes.
They are supporting the prosecution case. Although I was not examined. And
Doctor is not examined, IO is
And
not
doctor is
examined.
also
And the informant is the nephew of the injured. And he was involved in one of the molestation case with the daughter of the accused. So therefore, what he says is, this is a case falsely implicated. He has been falsely implicated. And because false implication, who will do it? At the instance of the police only.
Yes.
If you don't examine the IO, how will you confront?
And
The trial court is absolutely wrong. If the defense is false implication and with a reasoning, reason is the informant is accused in the molestation case of the accused. This is the reason. If the reason is given, then if IO would have been examined, if they would have confronted, how would you say that he is not prejudiced? He is completely prejudiced. Because of the nature of the defense taken by the my accused. And medical evidence is, there is no medical evidence at all.
Exhibit.
Whether injury, see, the court says the injury is simple in nature. Where from they got simple in nature? 324 they have got because he used farsa, it's all right.
Yes.
But where from he got
As per exhibit 3, but
where does it say simple? Show me from exhibit 3.
exhibit
Simple, grievous,
3,
whatever.
locksmith and
Rather, in the contrary, if you see the doctor, in the end, it is written nature grievous. Nature grievous. Just see at the last line,
yes.
exhibit.
Number.
And that relate to some injury which is old. In the bracket, it is written old injury, where stitches were there. How this injury has caused because of the farsa blow, that's not coming.
Initially.
It doesn't say, the first beginning. There was an old stitch wound. It starts with that. There was an old stitch wound. Thereafter, the operation takes place on 2/9/2002. Incident takes place in July. And he signs on October 2002. And this doctor. Who is this doctor? Dr. L. I don't know what is the name. LD Sahu. LD Sahu, maybe. But this doctor was not brought to the witness box. So in this kind of evidence, how will you do it? Merely because the injured and the wife says something.
Data exhibit 3.
Very simple. Number 2, defense plea in the present case is
Final opinion to be given by
informant
after
involved
specialist.
in
After
most of the
specialist
case,
report.
the doctor. Therefore, the accused has been falsely pleaded. In the present case, except the PW1, the informant, injured PW2, the injured, and PW3, the wife of the injured, who claims to be eyewitness. No other evidence that material for the prosecutions. Incidentally, the IO of the case has not been mentioned. It's like for 2 years. The doctor who has treated the injured has also been given. In the name of the medical evidence, Exhibit 3 has been placed on record. The Exhibit 3 is a letter written by the SIF police to also to the medical officer of district health DHH Kulo. In the said letter, the SIF police has written that the present accused has assaulted the injured on 26/7/2002 at about 8:30 p.m. by means of farsa, causing 2 injuries. Injuries as said. In the said exhibit, there are some endorsement by one doctor, LD Sahu. In the later part of the report, he has written that there was an old stitch wound which was operated upon on 2/9/2002, and the said doctor has signed on 9/10/2002. Neither the doctor nor the SIF police who is given who is exhibited to the who is written the so-called medical report has been examined by the police. The nature of defense taken by the accused required the IO to have been confronted. Therefore, Mr. Bose submits that non-examination of IO has greatly prejudiced the defense. Greatly prejudiced defense. Para 6. Para 6 of people. Judgment is.
Great.
Yes. 7. Yes.
May regularship Millard in the above criminal appeal, the present appellant Millard challenging the order to impose judgment.
Mr. Ponda, appointed Judge and Sipa. Yes. Yes.
Improved judgment Millard 31/10/1995, thereby the London Trial Court convicted the present appellant.
I made notes of submission that last part I also had that answer.
Which one?
Yes. Senior Mr. Bhavan, yes.
Item 5.
Shant din
Item 5.
Regarding pardon.
Hearing proceedings.
No, judgment reserve. Part it. Now, look into it. Translate it first. Then you can. Pardon.
The London Trial Court Millard convicted the present appellant for commission of offence under 76 for 7 years, and Millard imposed fine 5,000. Here Millard looked into the evidence of the PW1 prosecution informant cum victim Millard. Apparently Millard, in view of the evidence of the PW7 doctor, there is no recent sign and symptom of research. And on that ground, my lord, this honorable court also granted bail me on Friday order dated 6/12/2019. On that finding.
Bail is
Yes,
something
yes.
different.
Apart from that, my lord, the evidence of the prosecutors is not trustworthy at all. Look into the her evidence, my lord.
Let us see prosecutor's what is.
PW1.
PW1, yes.
In her evidence, it says that on that fateful day, my lord, on
It is only 376 conviction.
conviction.
Only 376.
376.
7 years.
It's separate conviction.
SST.
That's separate conviction case since my lord.
Accused is a
On
court.
3/1/1993, while she was Millard, her in-laws members, husband along with her sister-in-law and mother-in-law went Millard both, and she was sleeping alone in their room. The present appellant Millard entered in their room and committed Millard forcibly sexual intercourse with her.
Yes.
And on the very next day, after Millard arriving Millard, her family members, she disclosed before them. But in fact, her mother-in-law and sister-in-law not examined in this case, before whom he initially first disclosed the incident. But on the very next day, she was also Millard medically examined, and Millard, in view of the evidence of the doctor, that is PW7, there is no Millard recent sign and symptom of the sexual course, and particularly Millard, finding of the doctor Millard, within 48 hours, Millard, the sexual act not been done.
When the victim was examined.
4/3/1993 ହେଲା ଘଟଣା।
Let us read FIR 7/95, yes.
And the occurrence on 6/6/1995.
6/6/95 occurrence, okay.
So far the SC/ST prevention of atrocities rules.
Charge sheet filed when?
Charge sheet, my lord.
Rule 7 on 31,
3/1995.
31/3/95, na?
Yes, ma'am.
95. SC charge sheet. Close कर ले.
item.
Charge sheet is on.
Second available.
7:30. On 8/7/95. 8/7/95.
Let's shift over.
Yes, 8/7/95. And who is the who is filed SI?
SI.
SI police.
PW4 is the IU.
Filed by SI police. PW?
PW4 is the IU. ASI of
Yes, sir.
Lakshipur.
Yes, madam. Give your name. I will appoint her as MSc.
Nice.
Nobody is coming. Huh?
The other one is
Huh?
3/23.
Not coming. Not coming. Appoint her. Appoint her. But you have to give a written note of submission. Okay. Let her prepare. Let her prepare. Do it. Let her prepare. You prepare yourself. Take in the pen drive and prepare and give me. Huh?
From 3/20.
If Thursday.
Hey, 3/23 to 94 next week कौन हो?
Now, no, but see, let her read because she got an opportunity to read. That's the idea. Huh? No. Judgment reserve. Judgment reserve. Now we need to.
The other conviction is 3/23 to 94 1 month.
1 month. And SC/ST goes.
SC/ST goes.
SC/ST.
in lieu of that.
Okay. Only.
So far 3/23 is concerned, simple injury.
Everybody says, huh? Right, huh? Okay. PO, we'll do it PO. Huh? Do PO. We'll get it. We'll call it later. $323, na?
Yes, my lord. 3/23 to 94. 3/23, my lord, RI for 1 month and RI for 1 month for 294 also.
For 323 material is the doctor is there.
Yes, doctor is there. PW3 is the doctor, PW1 is the injury.
Just now give madam, you are sitting here, just see the paper book and 323 and 294 is made out. So probation of offenders give. And so far as SC/ST Act is concerned, the IO is ASI. So therefore, he has to wait. Okay. Just check it up and underline the portion and give it back. Yes. Okay. Which one? 14.
Item number 5 the first day.
5, huh?
Thursday.
Now, if you want to do it, we can proceed.
Well, here ballot was pleased to direct me to obtain instruction with regards to the other co-accused persons. I have obtained instructions, my lord, out of the rest accused persons. Two accused persons have died in the meantime. They have not faced trial. And main accused Panu, because who was named by all, he has faced trial and he has been acquitted. And
He has been also acquitted.
he has been acquitted. Judgment I have also brought ballot yesterday I got. And with regards to other 3, they are facing trial and almost all witnesses have been examined. They have also taught hostile. They are
Final judgment hasn't come.
No, they have taught hostile. Well, at like PW 6, 7, 8, and 9, there are 4 witnesses, those who have stated about the occurrence. And I had specifically categorized that they have named, say, 5 persons, those who have assaulted. Out of 5 persons, 3 have not faced trial. And out of 2, 1 has been acquitted. So because his name has not been stated by all the witnesses in that way. And also subsequently, these PW 6 and 7, those who are PW 6 and 9, 7 and 8, they're dead. They were examined in ST number, latter ST, with regards to.
Then let us see, who has been acquitted? You said Panu.
Yes, I have prepared a short note, but I will. What has actually happened? Here, 11 appellants are there. In fact, 15 persons were placed under trial. Out of 15, trial court was pleased to acquit Manu Naik.
Total 15.
Pilot.
Total 15 accused. Manu Naik, huh?
Manu Naik.
Manu Naik, huh? And?
Manu Naik, Nakula Naik.
Naik, yes.
Prafulla Naik and Sudarshan Sahu. They were accused numbers 2, 3, 5 and 8 in the
2, 3, 5.
2, 3, 5 and 8.
Now you said Manu, Nakula, Prafulla.
Prafulla, Sudarshan.
Sudarshan.
Sudarshan Sahu.
His accused number?
Ballot?
Sudarshan accused number?
Sudarshan is accused number 8.
8. All are acquitted.
They have been acquitted.
And out of
though charge sheet was submitted against 24. So out of 15 persons were placed under trial. And then out of 15, 11 have been convicted.
Panu is not tried at all.
No. Panu has been tried in ST number 23/109 of 99, and by judgment dated 13/2/2014, Panu has been acquitted by Additional Sessions Judge Khurda. Panu alias Prananath Chwal Singh. His judgment is this. There also this PW 6 and 7 have been raised.
Okay.
And the accused persons Rabi Naik, Bhagirathi Chua Singh, Hadia Naik, 3. They were placed under trial in ST number 5/20/95 in the court of ad hoc Additional Sessions Judge FTC Khurda, and they have been acquitted by judgment dated 11/1/2011.
Then total accused is 24.
Total accused is 24, charge sheeted. ସେଥିରୁ abscond କରି ଯାଇଥିଲେ 9 ଜଣ। 9 ଜଣରୁ ରବି ନାୟକ, ଭାଗୀରଥୀ ଛୁଆ ସିଂ and ହାଡିଆ ନାୟକ ଏଠି ଗୋଟେ ଟ୍ରାଏଲ ହେଲେ ST number 5/20/95.
Okay. ପାଣୁ ଗୋଟେ ହେଲା
23/109 of 99.
23/109 of 99. Panu. ये रवि
भागीरथी and हाड़िया
हाँ
तो माने ST number 5/20/95.
5/20/95. Huh? All acquitted. Then
And,
1, 2, 3, 4, 5, 6, 7, 8. 8 people got acquitted.
Again?
8 people got acquitted total.
4 4 8 हाँ
Hmm.
तापरे accused persons Raghuraj Sahu
Hmm.
and Gagan Naik alias Alia,
Hmm.
they are facing trial in ST number 65 by 08
Raghu
Gagan.
and Gagan.
Madam.
ST
65 by
65 by 2008.
huh? They are almost
Going on.
witness have examined cases posted to 16-3
Going on.
going on. And accused persons, namely Vijay Sethi,
Hmm.
another accused, is facing trial in 3 by 23 by 96.
ST case number 3 by
23 by 96 by 24. Empty console.
3/96 oblique
The 3 by 23
Hmm.
by 96 by
3 by
24
23
by 96
by 96
by 24.
to 2024.
Madam.
On.
Vijay Sethi.
Going on.
And
Going.
Golok Bihari Sahu and Pandari Naik,
Hmm.
they are dead.
Golok Pandari, they are okay.
They have not faced trial.
कितने जन हेलानी 1 2 3 4 5 6 7 8 9 10 କିଛି 15 25 ଜଣ ହେଇସାରିଲେଣି
24.
11 ଜଣ
Again,
24 ଜଣ total.
total.
But in this trial 15 people were there.
15 persons were there.
Hmm.
Out of them, 4 were acquitted.
Acquitted and
11 persons have
Hmm.
faced trial. And pendency of the appeal,
Hmm.
Udayanath Sahu, Jambu Sahu,
Oh, that I have noted.
Udiya Naik, and
Annama Naik.
Annama Naik, they are dead.
1 3 10 and 11. Like
1, 3, 10, and 11.
yes.
My lord, on an analysis of the evidence, I was going through, my lord,
Hmm.
that London Trial Court has disbelieved the new part which was introduced, though it was not there in the affair. Alleged dying declaration purported to have been made before PW 12 by the deceased, that has been disbelieved. Paragraph 14 of the judgment, London Trial Court, after a long elaborate analysis,
Para 12.
paragraph 14.
Let us see.
Lastly.
Page 11 of judgment.
Yes. Hey, where is para 14 just read it?
My lord.
N-
My lord?
Not being complacent with what he stated above. the
That has been
decision
disbelieved.
He relied upon, he further contended that the medical officer who
My lord, paragraph 14 towards the last, in that view of the matter, I am not in a position to persuade myself to rely upon the evidence with regards to dying declaration introduced by the prosecution. Page, judgment, internal page 12, last 4 lines. এটা দ্বিতীয় হয়েছে
Actually, to para
Paragraph-
12, that is para 12 in fact.
পাইলট
Para 12 in fact.
12
Hmm.
नहीं नहीं paragraph 12 13 জায়গার 13 14 15 টা দুই থর হয়ে যাচ্ছে পাইলট বেশি page 12 well, got it.
Hmm.
Page 12. In that view of the matter, comma, I am not in a position to persuade myself to rely upon the evidence with regards to dying declaration introduced by the prosecution.
Yes.
I know.
Yes, I got it.
দ্বিতীয় paragraph 15 লেখা হয়েছে
Para 15 actually. It got.
Okay?
Para 15.
Next paragraph ବି 15 ଅଛି
Hmm.
ତା ପର paragraph ଟା ବି 15 ଅଛି ତେଣୁ ମୁଁ ଭାବିଲି ଏଟା 14 ର କଣ୍ଟିନ୍ୟୁଏସନ କାରଣ 14 ରେ ଡିସ୍କସନ କରୁଛନ୍ତି ଡାଇଂ ଡିକ୍ଲାରେସନ ଉପରେ the cumulative effect of the evidence regarding to dying declaration paragraph 14 ରେ ଡିସ୍କସନ କରିକି ସଫର ହେବା କଥା ଆଉ ସେ paragraph ବି 15 କରିଦେଇଛନ୍ତି କିନ୍ତୁ ତା ପର paragraph ଟା ବି ଆଉଟ ଅଫ ପଏଣ୍ଟ ରେ ଯାଇଛନ୍ତି
Yes.
Six, 7, 8, 9 को भी partially disbelieve करछन court.
Yes.
But reaching at a conclusion, well, but in PW6 state he has stated categorically Jaladhar Balavansaray, Badiyar Singh, Panu, Raghunath, Rabi, Biju Sethi, they all assaulted. In between, Panu has been acquitted. Raghunath Rabi, which is material about that. Raghunath Sahu is facing trial now, and witnesses have already been examined. They have also hostile. And Rabi is also facing. Rabi has already been acquitted.
I think a chart has to be prepared.
Because I have prepared it. I prepared a note for my lord also.
Okay, then I understood. Judgment reserved.
And if my lord requires the evidence of other cases that I am told by the lawyer, he will give by Friday because Lord Assistant Judge, Additional Assistant Judge is on circuit to Vadpur. Because I had instructed with regards to Panu, it was applied on 27/1, but I got it 23/2 because I had instructed this will be required. But pertaining to the other persons, those who are facing trial and the witnesses have already been examined.
Same set of witness.
Same set of witness. Just to witnesses there.
Then there are, see, 1, 2, 3, 4, 5 trials have taken place.
Yes.
5 trials.
Madam.
And these same set of witnesses have deposed differently in different.
No, in the present case, they have deposed the way they were instructed. But in the latter cases, they have turned hostile.
Oh, that's right. So,
But different.
in all the cases, landed up in acquittal.
Ended up being
Except
acquitted.
this.
Two
What will
cases,
be-
two
what will
cases
be the
trial,
claim?
two cases trial is well.
Trial is also.
Going on, it's all right, but in
They have
the-
not hostile.
They have already hostile. So, how to deal with it?
Whether these witnesses can be termed to be reliable one, because the case of prosecution, as stated in the affair, that that witness PW5, he is not a witness to the occurrence. He said, "I heard." From whom he heard, that is not there. So presumption is that he has heard it from PW6, 7, 8, and 9. But PW6, 7, 8, 9 says they after witnessing the occurrence, we came and we stayed in our house. We have not stated anything to anyone till next day when police came to our village.
So, source of information.
Yes, and he says, "I have heard that deceased was accompanying with these witnesses to the field, to the mango top. But this witness, all the 6, 7, 8, 9, they says, we met him on the way." Entire system is different.
Contradiction, clear contradiction.
And he has named, say, A, B, C, D, because informant says these 4 persons have assaulted. The witnesses says different names.
Because it is
Because
a mob of
if it would not
24
have if it would not have been a case of 302, this sort of analysis.
Who is the doctor here?
Doctor is my lord, PW4.
PW4 is doctor.
My lord.
He wanted to give some judgment.
Yes,
Huh?
I will give some.
Do you have the judgments?
File is not with me because the file has not been given today.
Now, in the parted matter, he wanted to give some judgment, whether in this case or some other.
ठीक है जजमेंट दो
You wanted to give judgment in this case or what?
नहीं नहीं एक केस रे नहीं
ଆଉ ଗୋଟେ ଅଲଗା କେସ୍ ଯୋଉଟାକ
जोशी
ସିଡି
case.
ଏସିଡି
Five to ଶୁଣୁଛି.
मैंने
এটা file ଚାଲିଛି।
Item 5 is going on.
এটা তো file
5 ଚାଲିଛି
ହଁ।
ना ସେଇଦିନ ଯୋଉଟା ଥିଲା ଯୋଶୀ
ଗଲା ଡେଟ୍ ଯୋଉଟାକ ହିୟରିଂ ହେଇ କ୍ଲୋଜ ହେଇଥିଲା ସେଇଟା
କ୍ଲୋଜ ହେଇନି ସେଟା ଟୁ ବି ଟୁ ମେନସନ ଆସୁ ଗୁରୁବାର ଦିନ
To mention.
because ballot that in that case 3-4 points are involved in the sense
So I'll get it listed, which item number. देखो.
ଆଜି ନାହିଁ
No, no.
ଆଜି ଲିଷ୍ଟ ନାହିଁ
The other one. Judgment. We'll see. This is going on. Take the number he wants that it should be heard once again.
there are ballot 2-3 things that have come to my mind my daughter and friend may raise they are my case their case was
Case number he gives from.
I'll give the number there the case was occurrence has taken place in front of the house of the accused persons where the female accused
Bhargavi, yeah.
Bhargavi she has been acquitted an allegation against
Acid.
her was twice or thrice 3 occasions she had brought acid in a mug handed over to her sons but she has been acquitted case of the accused persons as stated in the complaint petition which has been exhibited as exhibit C there the case of the accused persons that the occurrence has taken place in the jewelry shop of
That's what I was saying. Where it has taken place, there is a doubt.
that has not been stated in the accused statement whether if something is spelled out from the records and if the plea has not been taken, whether the court can take note of it. There is a question which my lord, my learned friend should have raised, but I am raising on his behalf. That has, number of judicial pronouncements are there that in case of right of privacy,
Well, least it to be mentioned, we'll just.
so
take
that
5
it
minutes.
can be hard
5
again.
minutes of. Thursday. To mention the. ठीक है. हाँ. What doctor says here, PW4?
PW4. Injuries.
एक चीज नहीं सुनिए.
Well, let me see. On 6th August 2090, while I was in subdivisional hospital on police requisition, I conducted postmortem examination in respect of dead body of Dr. Patnaik being identified by so and so. There was a deep incised wound of size 3 inch into 1 inch into 1 inch, left leg about 2.5 inch above the left ankle joint on an anterior aspect affecting muscles and bone. There was a big hematoma surrounding the one. There was fracture of both tibia and fibula. There was 4 bruises in the back. On dissection, there was collection of blood surrounding the bruises. There was no mark of ligature on neck. The scalp was congested. No fracture of skull bone. There was no evidence of fracture of ribs, cartilages. All the internal organs like lung, heart, liver, kidney, spleen, stomach contained about 200 ml of semi-digested food. There was no abnormal smell. There was an incised wound of size 2 inch to 1 inch to half inch over left leg, about 2 inch below the left knee joint and interior aspect. There was an incised wound on right leg about 1 inch below the right knee joint and anterior aspect of size 1 inch into half inch. There was an incised wound of size 2 inch into 1 inch into half inch, about 1.5 inch below right elbow. Cause of death is most probably due to severe hemorrhage and shock caused by several incised wound and fracture
Yes,
of
that is that. I've seen. So then you have to give me a chart.
My lord, I will give it that.
You give me a chart.
I prepared it
which you have done.
because it is required.
Chart without that very
Right,
difficult
right.
to. Okay, we'll keep it. And
That
the
is on,
other matter that where we
Thursday.
Thursday. To be mentioned, in the morning only you do it so that partly you have. And any other matter, you are ready?
Item 14.
15.
14. 14. 2-3 small matters are there which Malad can complete. Item number 45 and 71. My learned friend is there. I was saying that it can be completed.
45 and
71. But 14 is a case of rape.
14 we will hear because it is 95 matter.
Pilot.
14 just after just.
The item 24. Mobile engaged with amicus party. SKC supposed to be.
Yes.
Last 2 weeks it is pending. If my not one, I can do one.
The third was arguing. Item 14. Let's see item 14. Item 14, na? 14. Let us see 14 what. Convicted for which offense? Then I find that. 14.
Yes. We don't hype in the.
14.
Here the appellant has been convicted for the offense under section 376, reduce section 3 of 31X I and 31X II, PC and ST, Prevention of University Act, and to undergo RI for 7 years and to pay a fine of rupees 2,000 for the offense under section 3.
Can I get those judgment where it says that the appellate court can award sentence less than the minimum in certain cases?
Assigning reasons.
Assigning reasons.
Judgments are there.
There are many judgments because see 7 years sentence here.
Right.
These appeals are pending in 90.
Assigning reasons, it can be earlier judgments in at present status it is not possible. But in earlier cases,
There are judgment which says that minimum, less than minimum also the appellate court can give, depending upon the circumstances.
But it is court is to assign reasons.
You have to give reasonings.
Correct.
Reason.
Is there.
Because in all these cases, 90s cases, 95, 97, the minimum sentence, if some leverage is there, we can reduce it. Then many cases can be disposed of in that way. Yes.
Now, my lord was also disposing good many criminal offences on PO Act.
PO.
Now the latest judgment of the apex court is PO Act.
That's what
case I was
if
arguing
you,
a case before Justice Nursing. He said, have you seen? Yes, I've seen that judgment.
the same thing now Supreme Court says.
My lord.
That you must give, you must apply mind, if possible, you give PO. That's what we have been doing it.
My lord.
Yes. Victim, PW?
Hype.
Hi.
Yes.
I know the accused PW3 and 4 my parents. During the period of occurrence, I was working as a maid servant in the house of the accused. I was engaged to work in the house of the accused since about 1 year prior to the occurrence. In course of such employment, I was residing in the accused house. The occurrence took place more than a year back in the month of
Also.
on a Wednesday.
Time of occurrence.
At the time of occurrence, accused.
Madam, may kindly take note of this ballot. In the month of Posa on a Wednesday.
Hmm.
And then a year back, she's deposing in the month of November 96, 5th November 96. 5/11, 96.
November.
And she says occurrence has taken place in the Wednesday. That comes ballot 31/1, 31/3.
5th November 96 is the date.
Ballot.
5th November 96. Okay.
Madam.
Yes. Hmm.
Also, Masare, Budhavar Dina.
At the time of occurrence, accused Vikas was alone present in the house and his family member were not there. The accused dragged me to his TV room and possibly laid me on the palanca. He lifted the sari which I was wearing
Part fifth.
The manager tells us the health insurance.
The boy,
The report is, because where are you working as a manager sells Star Health Insurance near Rukmani Cinema Hall.
It's either students like about putting procedure.
The report of 7/2/26. Maybe I say,
that means the career goes.
Yeah.
So he's in a private job, so if sentence is reduced also, he's saved. Conviction maintained, sentence is substantially reduced in view of. Yeah, okay. Let's see that. Many small matters.
Fifth question.
Fifth.
Fifth.
Fifth. Okay.
All better control. Item number 45 is very small matter.
45.
Second.
You will do it
Second.
after lunch.
After lunch.
24 man very smart.
Because he said small, you made it very small.
Before the, and he was saying, I'll take 1 minute.
1
Okay,
second.
let us see.
And the conviction is a 3048. In the sentence for 2 weeks matter. It already undergone 11 months.
I don't.
11 months already undergone.
Yes.
Already undergone कर दें?
He said he was a village squire. The allegation ki he injected intentionally. He was suffering for the disease, suffering from malaria. He gave the chloroquine.
When he was arrested?
Arrested on 1912-2000.
1912
2000.
2000.
And bail bond submitted on 22/11/2001.
Arrested 20
to 11
11
2001.
2001. Release, huh?
During the appeal, he was released on bail by this honorable court by miss case number.
No, then the total is how much it then?
More than 11 months. And,
11 months?
Almost 4 days.
11 months, 4 days, huh?
Yes.
4 days. During trial.
Yes.
And what happened to your trial?
Appellate trial court also granted bail after the conviction, my lord, because
Because 2 years sentence,
yes.
389.
And this honorable court was also granted bail on 7/10/2002.
Okay.
Managed to find it in the LCR page 198.
Now let us see the trial court judgment.
Yes.
Which paragraph it says? PW 1, 2, and 3.
Yes. Are the eyewitnesses? Doctor is PW 10.
Child was suffering from fever and
Fever.
he came to know that the accused was
He
taking,
administered 2 injections. 3-year-old boy, he died.
He's quick, huh?
Yes, sir. Since last 12 to 13 years, he was.
Suffering from malaria. And gave 2 injections.
After giving the first injection, the child becomes senseless. Even though the child becomes senseless, the accused stated that nothing will happen.
After half an hour, he administered another.
Yeah, another injection. So the child on the different buttock. Then the child died at that place.
Custody certificate is there.
Hmm?
Custody certificate is there.
There.
Witness.
He was in custody from 2012-2000 to 21/11/2001.
2012, 2000 to 20,
1/11/2001.
then
What are months?
11 months, or 3 days or something.
And 5/22 5/22 ବେଲ୍ କେତେ କଣ 1 year ହବ 11 ମାସ 12 ମାସ ହବ 12 ମାସ
Chloroquine injection. Yeah.
Chemical exams report of cells show, my lord.
Coming to the medical evidence, it has been clearly established that due to the chloroquine injection, 2 accused deceased died. Medical evidence also corroborates the prosecution story. Further, the material available on record that the accused was generally giving medicine and injection in the locality by his visit from door to door, and he has no method of to in the local area. The question comes just whether accused was legally entitled to take the evidence from him. There was no material.
analysis.
What is his qualification?
Chloroquine was detected in the viscera, my lord.
Hmm?
Chloroquine was detected in viscera.
No, that is all evidence is there.
Yes. And it is for the malaria, my lord.
Statement ରେ କଣ କହିଛି?
Right, the logic. Obviously, the accused was not intending to kill, rather want to save. It's the error of judgment. There is no practicing certificate and he did it. Therefore, 304.
Not a cat. No, want of occupation କଣ?
ମୁଁ ବି ଆଜ୍ଞା ଯେତେବେଳେ ଛୋଟ ଥିଲି ମୋ ବୁଢୀ ମା ଯାଇକି ଗାଁରେ ପାଖରେ ଯୋଉମାନେ
That is in the village, this happens. This will happens to discourage this kind of practice only. Yeah, I think that 3048 minimum.
2 years, my lord.
Minimum 2 years.
Yes.
Which may extend to 2 years. It's not minimum. May extend. The less than 2 years also, or fine or both. Yes,
Period under 12 months here.
period after them. Okay. This para.
2 years. May extended.
Just see. This paragraph.
Extended to 2 years or 5. 2 ବର୍ଷ ହେଇଛି ଆଉ। ପଳେଇଲା।
And
approach.
just for
हाँ, लिखी दो भाई। Make it.
Madam,
Hmm?
My name is there. It's
Yes,
hello, Edap, close it up.
already undergone conviction maintained. About 11 months he has already gone, 11 months 4, about half a sentence out of 2. Yes.
as going through the judgment, my lord is just asking whether appellate court can pass the minimum sentence. Definitely
No,
not.
less than minimum sentence.
Yes, definitely not.
No, there are just.
The
we can
recent decision of 26 my lord is saying.
Get that judgment,
Yes.
but the position, earlier position, the appellate court can do it in a, by signing reasons. By signing.
The recent case of the POSCO and the REV.
POXO is that's a different lineage plan. Because the statute says minimum means you can't go less than minimum. Yes.
Obliged.
Hmm?
60 plan ಆಗಲ್ಲ, tomorrow will
60, 60. 60. Who wants to do 60?
start.
1 year, 10.
If you wanted to do which item?
60, 30.
60. You got 9.
83 is a small matter.
33? Okay.
Hey, Tamari.
Yes. You got 6. Hmm? But what is the offense, madam, here?
It's 374-2, but it's comes under 15 days and under section 323 of IPC for 15 days for simple imprisonment.
Okay.
It's only the present appellant, present petitioner, before filing this case, before this matter, there is a civil dispute between the parties. And after that, this case.
Okay. Then I hear 33.
That is the
Oh, that's it.
27.
I'll hear one after another. Small matters I can discuss. It is only 15 days sentence. We'll see. Yes, what is the facts? Prosecution
It's
case.
that on 1998, 11/10/1998, about 9 to 10 AM, the informant was in her body, and the accused person just go through the other place, but there is the same place
Hmm.
where both use the same road. So
Now, you are also convicted under section 31XI of SC.
But there is no caste certificate as per their cross examination and as per their, if your lot.
What is the sentence then? Total sentence?
Sentence is 6 months. RI 6 months. For
354.
350.
Six month.
For the offense under 451.
6 month and fine.
And fine.
6 month sentence. You say 15 days. Huh?
There. Mistakenly, the printing is there.
Just check it up.
Yes,
I
sir.
think you just then find it out, huh?
Okay.
Because it's SC/ST 354 is also there.
But
This-
there is no caste certificate as per their cross examination, as per the house discharge certificate and the ROR of the house. That is no caste certificate. They are not the scheduled caste or scheduled tribe or any other Harijan caste.
Mhm.
As per their cross
Who has
examination.
investigated?
No,
Section Rule 7 is compliant. Just check. Rule 7. Because 2006 matter. Just check it, madam. You have to just go through, huh?
Yes.
Rule 7 position also this. After lunch, put it, huh? After lunch.
After lunch, you have to take up 3 p.m. I have and also an another.
You just finish it up and come by the time.
Each matter there.
Small pair mail. Yes, item 27. Mr. Gangadhar Tripathi is conducting the case. He's passed away. I have got a file. I have some time mailer. One time.
It is there, whenever you come, you do it. Don't worry.
I-
It is in the weekly list.
Week 27.
Prepare and come, no problem.
Next week, one week, I
Item number?
27.
Oh, round of photos.
I have to contact the
Yes.
appellant.
Yes.
Very gold matter.
27.
24.
Oh, no, you entered appearance already.
I file mail.
Right. So and so council submits that Mr. Gangadhar Tripathi was appearing for the appellant who had expired. Thereafter, he would be filing Wakalatnama and seeking instruction from his clients. And she seeks 1 week time. Is the matter in the next weekly file. Okay. Then which matters are there? Which one? 21. Huh? 21.
That's 21. 33 is another matter. 399 of 2006. I am said.
You made me to read. You made me to read 33.
No,
I'm
no,
reading.
that's ambiguous query, but
You are arguing 21.
yes.
Okay.
I'm also confused.
Therefore, there was a confusion. No problem. And you say 354 years? Huh?
It's confused so I
Okay.
otherwise this matter will be taken up Thursday and do this. That's
It's only fine of
fine of 500 and 15 days simple imprisonment.
what do you want? You want PO? Like give PO what? Are you aiming at a acquittal?
Acquittal, gossip. I don't know where is the client and it was
So therefore, I'll give PO and finish it up. Why?
Sentence undergoes the sentence that both the parties are on one locality in consideration circumstances of this and substance convict sentence payable 500 in default to undergo RI for a 15 days.
15 days only.
15 days.
Default sentence.
Then further sentence
No,
of
what?
500 in default of
Substantive sentence, let us see.
15 days fine and further different there.
No.
The file could be
Circumstances of the case.
No, 500 default to undergo SI for 15 days. That is the sentence.
Only fine is 500. In default, it is SI for 15 days.
it is further sentence to pay
Fine, bra. In default to undergo SI for 15 days.
sentence to pay
ସେ
500
ହେଲାନି ଦିଟା ପରା 323 294
ଦିଟାରେ 15 ଦିନ ଆଉ 500 ଟଙ୍କା ଫାଇନ
500
default-
fine in default 15 days. That's what. But you tell me.
and no finding that why the provisions of PO Act was not extended in view of the recent decision of the Honorable Apex Court that is Chellaman. Letting go provisions of PO Act.
But you tell me if there is a fine, probation can be granted.
Yes,
There is
that I
no
have,
substantive sentence.
yes, that I have,
ପାଞ୍ଚ
to,
ଟଙ୍କା ଦେଇକି ପଳେଇବେ ନହେଲେ।
that I have to go through.
If had there been a substantive sentence, then you can give section 4 benefit.
Fine, fine is
Fine for fine what PO?
500 ଟଙ୍କା
Because section 5 if you read, PO Act, there is also provision of fine.
Yes.
You can convert this fine to section 5 fine and grant PO. Section 5, if he doesn't pay, there is a procedure already for the purpose of recovery. Here, if we leave it like this, if he doesn't pay 500, then he has to suffer the imprisonment. But section 5 is different.
That will be realized too.
Realize. So we can we convert this fine to section 5 fine?
Okay.
We just in the lunchtime, just this is
Might
bigger
have
issue,
it.
otherwise we'll see if that will help in other cases also. Just check it up. Read section 5 of PO Act and juxtapose with this. Let us see. At 2 o'clock we'll see. 2 o'clock. Provision of offender sector. You have copy of
Mine.
books.
Unit 3 IPC corresponds to section 4 of the BNS. This defines the
53, yeah?
yes punishments.
Okay.
The punishments to which offenders are liable under the provisions of the code are death, imprisonment for life, imprisonment which is of two descriptions, namely rigorous, that is with hard labor, simple, forfeiture of property. Sixthly, fine.
Hmm.
This word punishment includes fine. Now you will also kindly see the POI.
Pure.
When section 3 says, when any person is found guilty of having committed an offense punishable under section 379, 380 or section 381, section 404 or section 420 of IPC, or any offense punishable with imprisonment for not more than 2 years or with fine.
Or with both.
Or with both under the Indian Penal Code or any other law, and no previous conviction is proved against him, and the court by which the person is found guilty is of opinion that having regard to the circumstances of the case, including the nature of the offence, the character of the offender, it is expedient so to do, then notwithstanding anything contained in any other law for the time being in force, the court may, instead of
So there is
sentencing him
a
to
simple,
any
simple
punishment,
even if it is only with fine,
it can be
provisional can be given.
Decision of 6 SCC.
Give it that.
Paragraph 9.
Para 9, na? Yes.
The court is empowered to release an offender who is convicted an offence punishable with imprisonment for not more than 2 years or with fine or with both.
Or with fine, yes.
So the only restriction is death or punishment should not be death or imprisonment for life. Even if only sentenced to fine, then
And
also,
if there is a statutory bar in
Yes.
PC Act and all, there is a statutory bar. Apart from that, then you will make it pure. Okay. Pure. Pure. ठीक है. 60. 60, huh?
Item 60.
Yes, madam.
The appellants have faced trial being charged under section 307-34 IPC, while judgment dated 11/9/2009, the learned additional session judge, Fast Track Court 2 Bhadrak, found them guilty under section 324/34 IPC, sentenced them to undergo RI for 1 year. Here, my lord, prosecution story is that the informant and the appellant both are brothers. And on 15/5/2008 at about 7 a.m., when the appellants obstruct the path of the informant by throwing water, when the informant protested, he was assaulted by the appellants and by a stick, causing bleeding injury. And on seeing that, when his daughter came, she also assaulted by the appellants and their son. And some co-villagers, they came to the spot, and when they intervened, they were also assaulted. And FIR was lost, and charge sheet was submitted, and this is all about the prosecution story, my lord. Here, my lord, prosecution had examined 7 witnesses. PW1 is the informant. PW2 is the daughter of the informant. And PW3 is a co-villager, and he occurrence to the witness. And PW4 is a co-villager, occurrence to the witness and injured. And PW5 is also a co-villager and occurrence to the witness and also the injured.
PW4 and 5 are injured.
PW4 and 5. PW4 and 5.
W1 also.
One also.
1, 2, they are the informant 1.
No, injured. Who all are they?
Injured, your lords. Then
Injured are PW1,
2, 4, and 5.
1, 2, 4, 5. Injured.
Then PW6 is a doctor who had examined PWs 1, 2, 4, and 5.
Yes.
Then PW7 is the IO. Here, my lord, basing on 3 to 4 points, I'll make my submission. First, we'll come to, my lord, PW1. PW1 is saying something, PW2 is saying something, lodging of FIR. It is whole about, it is doubtful, lodging of FIR. What PW1 is said that he and PW2 were admitted as indoor patients, and he has stated at 4 p.m. he lodged the FIR, and FIR was scribed at Basudevpur Tahsil office. After assault, he gained sense in the evening of the occurrence day, as he was saying.
How many accused persons were there initially?
My lord,
Two accused persons.
2.
They-
Another is juvenile.
Another is juvenile,
Juvenile.
their son. My lord, kindly have a glance evidence of PW1.
Now this appeal is filed by two of them.
Raghunath Mahakur and Purnima.
Purnima Hakur is PW2.
Who is juvenile? Who was juvenile?
Appellant's son.
The other accused,
Then 3 accused persons.
Gautam Mahakur.
Three accused. Okay. Accused persons.
Son is juvenile, lord, my lord. My lord, kindly have a glance on evidence of PW1. Para cross-examination.
First paragraph, read it. At the occurrence time,
Cross-examination.
accused persons were obstructing our road pouring water, to which I protested. Then the accused Raghunath brought out a stick and assaulted me on my head. Another accused,
Gautam Mahakur, the son of the accused,
assaulted by means of an axe
on my head, for which I sustained bleeding injury. On seeing assault on me, my daughter who is PW2, my lord, he came out from the house and protested, but the accused person assaulted her by means of stick on her head. As a result of the assault, she also sustained bleeding injury on her head. After assaulting me and my daughter, the present accused persons and accused person Bhakta Maha fled away from the spot. After the occurrence, some of our relatives and villagers shifted us to Basudevpur Medical for treatment. At that time, myself and my daughter were unconscious. My lord, kindly be noted, he at that time, the PW1, who is the informant, he was unconscious. We both were admitted as indoor patients at Basudevpur Medical. At about 4 p.m., I reported the matter before the police by lodging an FIR. My lord, kindly have a glance on cross-examination.
Yes.
Prior to 3 days from today, the discharge certificate has been issued in my favor. On that day, the discharge certificate in favor of my daughter has also been issued. I cannot name the person from whom I received the discharge certificate. I also cannot say his designation. The discharge certificate was prepared in my presence. I was discharged from the medical in the evening of 8/4/2008, my lord. The occurrence was 15/5/2008.
15/5.
15/5/2008. Here he is saying discharged from 18/4/2008.
Maybe typo.
Yes, my lord.
Maybe typo. Yes.
Then I cannot say who had come to the occurrence spot after the assault on my daughter. After assault on me, I became unconscious. PW1, who is the informant, he became unconscious. There was some land dispute, civil dispute between the appellants and the informant, my lord. So there may be a false case, may be foisted against.
That may be the reason also
Maybe,
for
yes.
fight.
My lord, kindly have a glance on para 4 of the cross-examination, that PW1. Prior to becoming unconscious, I shouted and called Dukhiram for help. The affair was scribed at Basudepur Tahsil office. The scribe was working as Maurya. The affair was scribed. I was unconscious. After the assault, I regained my sense on the evening of the occurrence day. Later on, I came to know that my daughter had gone to near the scribe to instruct him. At about 4 p.m., my nephew Aniruddha told me to put my signature in the
What do you
FI.
want to point out?
My lord, here PW1 saying I was unconscious. That means he couldn't come to lodge the affair. But here PW2 has stated, kindly have a glance on PW2, my lord. PW1 saying PW2 has had gone to scribe the affair. But here PW2, my lord, PW2 para 2, my lord. On the same day at about 10 p.m., I regained my sense at Basudepur Medical. The medical officer recorded my statement there as my condition was serious. At that time, PW2 was serious. So it is not possible for her to come to scribe the affair, my lord.
Let us come to 1A once again. Where does it say that PW2 has gone? Which part?
PW2 para 2, my lord. Evidence of
And he
PW2.
says, as per my instruction, one of my relative, Parsuram,
Yes.
Mahakot, scribed the affair.
My lord, PW, which portion, my lord?
PW1 I am reading.
PW.
PW1, I am reading. Next, para page 2.
Yes, my lord.
After the occurrence, some of our relatives and villagers shifted us to medical, so and so. At that time, myself and my daughter were unconscious. We both were admitted as indoor patient. At 4 p.m., I reported the matter before the police by lodging an FIR. As per my instruction, one of my relative Purushottam has scribed the FIR.
Parsuram scribed the
And read over the so and so. Thereafter, I signed the FIR so and so. Later, I came to know that one of my brother, Dukhiram, and nephew so and so were also assaulted by the accused persons, and after the assault so and so. What do you want to say that?
My lord, somewhere he is saying ki, I was unconscious at that time, and PW2 had
It
gone.
appears that in the FIR he is dictated the relative who has written.
Yeah, Parsuram scribed the somewhere says Parsuram scribed the affair, and PW2 had scribed the affair, and PW2 at that time PW2 was unconscious, and
Parsuram is PW2.
No, PW2 is the daughter of the informant, my lord.
No, what does it say that PW2 has scribed the FIR?
PW1 saying that.
Where is that?
Yes, my lord.
PW1 only I am reading. PW1 only says that it is Parsuram.
Para 4. Cross-examination.
Para 4.
Cross-examination of para 4, my lord.
Prior to unconscious, I shouted and Dukhiram, and for me, a fire was scribed at Basudepur Tahsil. Scribe was working.
Sir, I regained my sense on the evening
When
of the
I
occurrence day.
scribed,
Later, I came to know that my daughter had gone to near the scribe to instruct him. At 4 p.m., my nephew Aniruddha told me to put my signature in the FIR.
Only you told me to put my signature in the file. Yes, all of them may be in the hospital, it seems.
There
My
are
lord.
some contradictions with regard to the manner.
There is a serious discrepancy, my lord.
That was directed by the learned trial.
How would they did it?
PW,
15.
my lord, PW1 is saying something, PW2 is saying something, PW3 is
Insofar as the registration of FIR is concerned.
lodging
Let's
of
see
and
how the trial court deals with it.
Para 15. There is nothing so far as manner of occurrence is concerned. It's not that the occurrence did not take assault.
Of course,
Of course,
an important
feature
feature.
worth noticing in the present case is that the evidence with regard to the post-occurrence scenario, that is with regard to the lodging of the FIR before the police, adduced by the witnesses are contradictory to each other. Though the informant PW1 has stated that he has lodged the FIR Exhibit 1 before the police and has proved the same during cross-examination. During cross-examination, he has stated that till the night of the occurrence day, he was unconscious and his doctor had gone to the scribe to instruct him to scribe the FIR. But PW2 has stated that she also
Unconscious.
unconscious for quite a long time after the occurrence and was no way connected with the lodging of the FIR. The other witnesses have stated in this regard that immediately after the occurrence, they rushed to the police station and lodged the FIR. Even in this regard, PW3 has gone to the extent of stating that he has put his signature in the FIR and has handed over the FIR to the police. As per the evidence of the investigating officer PW7, the FIR in this case has been lodged at about 4:15 p.m. on the occurrence day. Therefore, the evidence adduced by the witnesses in this regard are contradictory to each other and does not inspire confidence. But the witnesses are rustic villagers and thus their evidence with regard to the post-occurrence scenario, that is with regard to the lodging of the FIR before police, even if contradictory to each other, can be ignored as same does not affect the material part of the occurrence. Further, the principle is well established that the FIR is not a substantive piece of evidence and its only purpose is to contradict or corroborate its author.
Yes.
But no contradiction has been brought out by the difference between the FIR and the evidence of the informant PW1. The FIR is not contradictory, rather fully corroborative to the version of the informant PW1.
Yes, madam.
And my lord, PW medical examination report, what doctor says PW6 says,
There are 4 injured witnesses. They have narrated the incident, how these people have attacked.
my lord, 4 and 5 are not injured. PW 4 and 5. Prosecution has not proved that 4 and 5 are injured, my lord, and occurrence to the
Let
witness.
us see the doctor. 6.
PW6,
Kiram is PW.
my lord,
Who is Dukiram?
PW4.
PW4.
First PW4 only he examined. Doctor. Yes, he
My lord, PW, shall I read?
sustained 1 injury.
PW4, my lord.
Yes, no, PW7 if you 6 you should go. Put
PW6, my lord.
6.
Yes, my lord. My lord, cross examination.
No, come go. He has examined whom? He has examined PW.
He has examined 1,
4.
2, 4, and 5.
Then why do you say that 4 and 5 were not there? They are injured witnesses.
Yes, my lord, I'll come. I'm coming to the point. Cross examination. It is the fact, PW6. It is a fact that prior to receiving the police requisition, I have examined the injured persons, but after the police requisition, I have prepared the injury reports. From my personal notebook, I have prepared the injury reports. I have not produced that personal notebook before the police. In the injury report, it has not been mentioned that any of the injured persons have been admitted in the medical as an indoor patients. Though the injured persons have treated in emergency ward, the emergency requisition number had not been mentioned in the injury reports.
Yes.
And my lord, PW7 IO says, my lord, page 2, my lord, PW7.
Yes.
The informant has scribed the FIR personally I have issued injury requisition in favor of the injured Vaikuntha and Dukhira at 9:10 p.m. on the occurrence date. Prior to their medical exam, they had come to me. I had not examined any of the injured person at the medical. And the occurrence spot, my lord, para 4, the occurrence spot situates towards the north. Here, PW7 says that the informant has tried the affair. The informant
That you have already said that the registration of FIR is doubtful. The trial court deals with it, that
Yes, my lord.
para 15. That about what do you have?
My lord, kindly have a glance on PW3.
Yes.
PW3, my lord, first page, just last line. As Bhagirathi had also sustained some injury during the course of quarrel with the accused person, we also shifted him to the medical. Cross-examination. The occurrence continued for about 15 minutes. The occurrence took place in front of the house of the accused persons. After the occurrence, I shifted the injured. PW3 shifted. I shifted the PW Mangalata to the medical by motorcycle. She had sustained injury on her forehead and blood was oozing out from there. The informant Bhagirathi and his daughter Mangalata went to PS first, then to the medical. I had also gone to the PS. FIR was scribed there and was handed over to police. I had put my signature in the FIR. I had handed over to FIR.
That is what the trial court deals with. He went to the extent that I have myself signed it.
Is SPW3 saying that I?
That point is well taken. Apart from that, you
Yes.
say FIR is registration of FIR is doubtful.
My lord, please then come to PW4.
Regarding what? Don't lever on that point. Injured witness's statement corroborates with the medical evidence. How will you get over that?
Yes, ma'am. Yes, ma'am. I'll come. Fine. And my lord, a weapon of offense that has not been seized.
Not covered.
No, my lord.
Yes.
And medico-legal case, my lord. The injured are examined first in medical, non-reporting of medico-legal case at PS creates, my lord. Examination it as much as PW6.
The weapon of offense is
Offense has been seized.
axe and stick.
My lord, axe that is used by the son of the appellant's juvenile. Only appellants they have used by stick. So that weapon of offense that has not been seized.
Axe is also not seized.
Yes, no, nothing has been seized. Neither stick or axe.
It was not shown to the doctor also. Huh?
No.
Yes.
The evidence of PW6, my lord, he had examined PW1, 2, 4, 5 on 15/5/2008 on police requisition, but then he has also stated that prior to receive the police requisition, he had examined the injured persons, but after the police requisition, he had prepared the injury report. He has admitted that the injury report does not mention that any of injured persons had been admitted in the medical as injured patient.
These are simple injuries.
They are my lord, simple injury.
324 is only because of the weapon of offense which you have used.
My lord,
Deadly
weapon of offense has not been seized, and since there is a civil dispute between them, so maybe false case may be foisted against the appellants.
Reverse may be also corrected.
And my lord,
Because there was enmity, therefore you have attacked.
and lodging of affair, my lord, anti-timing, anti-dating of lodging of affair, that is also doubtful. PW1 says something, PW2 says something. So this is all about the whole prosecution story is, my lord, doubtful. And as far as PW4 and 5 is concerned, my lord,
What you have undergone?
and my lord, here prosecution has failed to prove PW5, 4 and 5 are injured. And they are the witness to the occurrence, my lord.
Why?
So, I'll come.
4 has been examined by the doctor.
4, 5, they have not examined by the doctor and they have.
No, 4 has been examined. 4 has been examined.
He, PW6, he has stated that he has prepared the injury report from his personal notebook. He has also.
Come to pay PW6, first paragraph.
PW6.
On that day, on police requisition, I examined Dukiram Mahakut, that is PW4, and found the following injuries. PW4 was examined by the doctor. Next, Vaikuntha,
PW5.
Vaikuntha Mahakut, PW5. How do you say they are not there? They were examined by the doctor.
My lord, they have examined by the doctor, but 1 minute, my lord. I have.
They've received simple injuries. That is a different story.
Yes, my lord. Simple injury is there.
Hmm.
Yes, ma'am. My lord, basing on that weapon of offense that has not been seized.
You said that.
And so 4, 5, though 4, 5 injured, but they have not admitted that at that time. And basing on medical exam, basing on that medical legal case and affair, lodging of affair, I'm.
You are only one point is well taken, is that the FIR.
My lord, affair.
FIR doubt.
And weapon of offense, my lord, that has not been seized. So doctor says, my lord.
But you have not said anything why the injured witnesses, 4 of them have stayed against you, and doctor is testifying, and that corroborates. That's the important thing. Yes, Mr. Panili.
This is there. During the fact that more than 17 years have already found.
You give PO, madam.
Yeah.
Both are now more than 60 years of age.
My lord, PW2 is a lady, my lord. He.
Probation of offenders act to anybody. They not go to jail. What is the sentence? 2 years.
1 year. 1 year.
Oh, pure. Pure. ठीक है. Anything remain कितना total? Thursday. Yes. All no, so but small, but there are 6 matters today. We'll finish it up, no? Okay.